Further hearing in the appeal, Lescene Edwards against the Queen.
Good morning, Mr. Poole.
Good morning. My Lord, my Lady, yesterday I was dealing with delay and the effect it's said to have had on the fairness of the appellant's trial, and I dealt with 3 of 7 complaints made by the appellant, so I just propose first to deal with the remaining 4. The 4th complaint is the absence of Dr. Shisiah. Now, the evidence, as I think we were reminded of yesterday, was Dr. Shisiah left Jamaica on the 8th of August 2009, and the reference for that is at 449. He was working and living in India, and there was evidence that it cost some 400,000 Jamaican dollars to return him to Jamaica to give evidence at trial. And in my submission, unsurprisingly, the Crown was given permission for a colleague, Dr. Prasad, to put the post-mortem report in evidence and speak to it. There does appear to have been some discussion between the Crown and the defence as to those arrangements, because in the transcript it's recorded Crown Counsel saying that the defence had confirmed that no issue was taken as to the process of the post-mortem. The references for that are 427 to 428. The short submission I make there is that Dr. Prasad said all that could reliably be said by a pathologist in a case of this nature, and it is speculation in my submission to suggest that Dr. Shisiah could have said or expressed a view, anything that would have assisted the jury as to whether this death was suicide. The particular points of Dr. Prasad's evidence, the board will have these already. He confirmed that the trajectory of the bullet was upwards, backwards, and to the left. The 2 references to that are at 558, line 24, to 559, line 1, and the second reference at 582, line 8. And he also stated that the margins and discoloration of the entrance wound were consistent with a tight contact, and that's at 582, lines 18 to 19, and 583, line 9. That evidence allowed the defence to invite the jury to infer that the trajectory of the bullet and the tight contact wound were more readily explained by suicide than being shot by the appellant. And in my submission, no prejudice was sustained by Dr. Shisiah's unavailability at trial. The 5th complaint under delay is fading memories. Now, the appellant makes the point that the witness's memories would naturally have diminished over a period of 10 years. Now, obviously, that general proposition, no doubt, is correct. It was a point that the judge made to the jury on more than one occasion in her summing up, and the board have those references at paragraph 50A of our printed case, which is 2324. In any event, in my submission, the board ought to be looking for specific prejudice, and the only instance relied on under this head of complaint by the appellant is that the deceased's niece was unable to remember whether there was blood on the door jamb. The significance of this, though, is something that Miss Leake, in her joint report, does not opine on, and in my submission, the photographs taken of the scene showed where the blood was, and so any failure on the part of the deceased's niece did not present any problem for the defence, whose case was, in any event, that the door was closed. The 6th delay complaint can be characterised as really general investigation failures. The Court of Appeal deal with this at paragraph 57 of its judgment at page 1930. And in my submission, I submit that the Court of Appeal was entitled to express the view that it did there in respect of the investigation. There are 2 specific points taken by the appellant at paragraph 36 of his case. The first, it is said that the police were under a duty to send the gun for forensic testing. Now, I dealt with this point yesterday. Firstly, there's no evidence that fingerprints could have been taken from the gun, and even if fingerprints could have been taken or DNA taken that matched the deceased, in my submission, that would not have assisted the jury, given the Crown's case that this was a staged suicide. Now, obviously, I accept that there's a difference between absence of evidence and evidence of absence, but...
Well, I wonder about that. I mean, the Crown's case is that it's a staged suicide, but if the deceased's fingerprints were on, say, the trigger of the gun, would that not be something that was rather valuable to the defence? If there were no deceased fingerprints, clearly that would be of no assistance to the defence. But why do you say that evidence of the deceased fingerprints would not help, because it was a staged suicide?
Because, my lord, the Crown's case was the staging of the suicide would have included the appellant putting the gun in the right hand of the deceased. Hence why the Crown's case was he then handled the gun after the event. So either fingerprints and DNA would have matched the deceased.
You mean putting it in her hand after he'd shot her?
My lord, yes. So either fingerprints and DNA would have matched the deceased, in which case that would be explicable by it being a staged suicide, or they wouldn't have matched the deceased, which would have been unhelpful evidence for the appellant. But I go back to the first point, which is there is in fact no evidence before this board that fingerprints could have been taken from the gun, and I gave you the references yesterday to the police evidence on that, which was not challenged, that fingerprints could not have been collected from the gun. And I made the point also that that's not challenged on the fresh evidence either by Mr Mistaglio or Miss Leake, or sorry, Miss Shaw rather. And the second point that's made by the appellant is that the police should have swabbed the bathroom walls for gunshot residue. Now, this complaint is in fact answered by the fresh evidence, because Miss Shaw and Mr Mistaglio confirmed that the collection of GSR from the bathroom would have been unlikely to assist in establishing who fired the fatal shot. And we see that's at page 2104. It's answer Roman 4B, and also at 2108, answer Roman 5 little c. The final delay complaint relates to the cleaning of the scene. The complaint being that the Court of Appeal's conclusions regarding the lack of prejudice caused by cleaning are perverse. I submit that this complaint is without any merit, and the Court of Appeal were correct to reject this complaint. And dealing with the points that are made at paragraph 39 of the appellant's printed case, which is 2264, the blood spatter was captured in a series of detailed photographs prior to the bathroom being cleaned. The defence used those photographs when inviting the jury to conclude that blood pattern, the trajectory of the bullet, position of the body, location of the gun, height of the bullet hole are more readily explained by the deceased shooting herself. And in fact, the lack of any evidence of a struggle supported the defence case of suicide, and the lack of any evidence that there was someone else in the bathroom also supported the defence case of suicide. The final point in the constitutional appeal I can take very quickly. It's the delay in the appeal proceedings as opposed to the delay between the interview and conviction. There's a 21-month delay in the Court of Appeal delivering its judgment. Now, obviously, the respondent accepts that this is an unsatisfactory length of time to be waiting for judgment, and the Court of Appeal, in fact, expressed its sincere regret for that delay at the end of its judgment, which is at page 1966. The important point, obviously, on the constitutional complaint is prejudice, and the appellant quite rightly accepts that he's not been prejudiced. This isn't a sort of fresh evidence case before the Court of Appeal, so that the probative value could have diminished. So I say...
Well, might not that depend on the outcome of this appeal?
My Lord, insofar as what it does obviously relate to is whether the respondent was inviting this board, if it's against it, to order a retrial. We don't invite your lordships and your ladyship's board to order a retrial in the event that you're against me and you find that this is an unsafe conviction.
Well, if he succeeds on this appeal, then he's had to, it's added on 2.5 years to his time in prison.
My Lord, yes. In that regard, the length of delay has increased the sentence. I would obviously accept.
But in a sense, that isn't relevant to the matter that is in dispute between the appellant and the respondent. You accept that a declaration might be appropriate, that there's a breach of constitutional right. What you take issue with is the effect of the delay on the fairness of the trial, and what happened in the Court of Appeal, however regrettable, had no effect on the previous trial.
My Lord, that's right. And obviously there can be cases where, if you're relying on fresh evidence in the Court of Appeal, that may not be the case. But this
is a case where the fresh evidence has come later.
Absolutely, my Lord.
Yes.
Does the delay have any effect on the application of the proviso?
No, my lady. Turning to the conviction appeal, and as I said at the outset yesterday afternoon, I'll work through the 6 grounds of appeal in the order that they've been dealt with by my learned friend for the appellant. So the first is lurking doubt. The response to ground 1 is set out in our printed case at paragraphs 17 to 27, which starts at 2311. Now, in short, we say this is not a lurking doubt case with or without the fresh evidence. I propose to deal first with the fresh evidence and then deal with the evidence called at trial. And the point was, I don't take issue with the discussion that was had yesterday, prompted by my Lord in question. If we're dealing with fresh evidence, then I entirely accept that this is a Stafford Pendleton Dial type case, so it's not lurking doubt in that sense. You're only looking at lurking doubt when you're looking at the evidence called at trial.
And it's right, isn't it, that even putting the fresh evidence to one side, cases such as Lau or Pope in this jurisdiction are about appeals where the ground of appeal is that the jury verdict was against the weight of the evidence. They're not about cases where the defence has a different viable ground of appeal, such as the judge's summing up was unsatisfactory.
My Lord, that's right. That's right. And as the Lord Judge said in Pope, that was, as your Lordship says, about the jury's decision of verdict being against the weight of evidence, and that's why it would be an exceptional case where lurking doubt provides a successful ground of appeal.
Thank you.
The Respondent's overarching submission in respect of the fresh evidence is that no injustice will be caused by refusing to admit it, because we say the expert's evidence, properly analysed, does not go very far and does not cast doubt on the safety of the appellant's conviction. Briefly as to the test, because there's really nothing between us on this, the applicable test is whether the new evidence should be admitted in the interest of justice. We agree with the appellant that when this board is looking at the fresh evidence, it should apply a series of sequential tests, as was set out by Lord Kerr in Lundy, which your Lordship, my lady, has been taken to. It's starting at 2666, and it's paragraph 120 of that judgment. Now, in the present case, there's no issue taken as to credibility of the new evidence, in the sense that it is certainly capable of belief. The issues are, therefore, whether it could have been obtained for trial or in the Court of Appeal with reasonable diligence, and then secondly, whether its admission has any effect on the safety of the conviction. There is one point on Lundy. I submit that the present case is not one where the case against the appellant rested exclusively or principally on scientific evidence. So when, I think my own friend refers certainly in the printed case to what Lord Kerr said at paragraph 122 of Lundy, namely where you've got a case where new scientific material has been provided, that should not readily be excluded. In my submission, that has no application to the present case.
Well, what other evidence was there, apart from the handwriting and the lack of gunshot residue?
No, sorry, my Lord. My point being that there's been no developments. For example, if this was relying on DNA, sometimes you have DNA cases where there's been a breakthrough in the science in relating to DNA, and that is, I think,
Is that what's being referred to?
That's what Lord Kerr.
The science has changed.
Paragraph 122, where science has changed. There's been some kind of breakthrough, and that kind of evidence should not be readily excluded. And my short point is that that's not this case.
No, I see.
Even on the gunshot residue, that's not this case. It may be that Jamaica was not using the most up-to-date testing for gunshot residue, but that testing was available elsewhere. And I'll come on to that when looking at Ms Shaw's evidence in a moment. The first point that we do take, but I'll take quickly, it's that the evidence could have been obtained with reasonable diligence at trial. And we set this out at paragraph 21 of our written case, page 2312. And your Lordships, my lady, has really heard what I said yesterday on this. You've got the witness statement of counsel for the defendant at trial, Miss Nita Robertson, which demonstrates that a deliberate decision was taken by the appellant to use his resources to focus on handwriting rather than GSR, blood spatter, ballistics. So save for lack of resources, there is no suggestion that the expert evidence that's now being put before this board could not have been relied upon at trial, nor save for resources that it couldn't have been relied upon in the Court of Appeal.
Well, that's a pretty big saving, isn't it?
My Lord, I accept...
Which of the experts should he have chosen out of the three, you suggest?
Sorry, my Lord.
If he only had enough money for one expert, which one should he have chosen?
Well, my Lord, it is right to say that the respondent has not sort of challenged what Miss Nita Robertson has said in her affidavit. No. But this isn't... and we had some discussion yesterday about legal aid. This is a appellant who has continued to work whilst on bail, and obviously we haven't...
Well, I think as a bus driver.
My Lord, yes, indeed. And the short point is, yes, I accept lack of resources can found a reason, but that is the only reason in this case that's being relied on, and that is...
Is it? I mean, the relevant expertise was not readily available in Jamaica. I mean, the appellant has had to come to the United Kingdom to get the scientific evidence which he now seeks to adduce.
Well, my Lord, the relevant handwriting expert was obtained from outside Jamaica. The evidence is that there was no blood spatter analyst on Jamaica, but would have been available, for example, in the States.
Yes.
As I say, I accept lack of resources can found a reason, but that is the only reason, and that is a factor that should weigh against the appellant being able to rely. But on this evidence now, I do say, though, the main point is that it's whether it's in the interest of justice to admit it, and the effect it would have. And as to that, I'll move to deal with the three experts in turn. I'll start with Miss Shaw, if I may. Miss Shaw effectively makes 2 points in her evidence. First, the absence of gunshot residue on the nightdress, she says, calls into question the reliability of testing methods. And my learned friend relies on that to say, effectively, that debunks the central plank of the Crown's case. And the second point Ms Shaw makes is that more reliable methods could have been used to analyse the samples for gunshot residue. Before addressing... Well,
I would put the point in terms of saying that the method used was one that hasn't been used for several decades in most jurisdictions due to its lack of specificity and sensitivity.
My Lord, that is right.
Well, that's a very important point, isn't it, when you're considering whether any inference can be drawn from the lack of finding of gunshot residue?
My Lord, the point, though, is that the Harrison and Gilroy GSR testing method was the only method available in Jamaica at the time.
Well, it may have been, but the question is, why wasn't any gunshot residue found? And the argument at the trial was all about, oh, well, you might not have been able to detect it because the humidity in the morgue or something. If you know that, in fact, it's a very unsatisfactory method that doesn't work very well anyway, that casts a rather different light on it.
But, my Lord, if the criticism is being made of the testing and the police were using the only available method of testing available at that time, then I say that is they can't be criticised for using the Harrison-Gilroy GSR testing method.
No, the police can't be criticised if that's all they have. And I think, as you said in your written case, the witness in question, the expert witness for the Crown, was cautious as to what could be deduced. But it appears from the summing up that the Crown were not so cautious, and that the absence of GSR was one of the central planks of the case made against the accused.
My Lord, as I said yesterday, I accept that the absence of GSR was one of the strands of circumstantial evidence that was relied on. I don't accept that it was a central plank, or one of the central planks of the prosecution's case.
It's mentioned 3 times in some detail by the learned judge in summing up.
Lord, I accept that it is, but it was clearly the central plank of the prosecution case, the handwriting evidence. All other strands of circumstantial evidence were not afforded, in my submission, more weight by the Crown than any other. I'll come on to the summing up when I address grounds 5 and 6. But that's my sort of overarching submission on that. But there is a point, though, on Miss Shaw's evidence, because Miss Shaw, when she is looking at how the GSR evidence was presented at trial, in my submission, arguably falls into error, because she focuses on Superintendent Hibbert's statement. And we see this at page 2100, which is Miss Shaw's report, at the very top of that page, where she refers to an undated statement from Superintendent Hibbert, in which he said the results of the GSR testing were negative, quote, which indicates that the deceased did not fire a firearm, unquote.
Oh, yes.
And we see that again referred to by Ms Shaw at page 2107 in answer to question Roman 4 little f. And Ms Shaw makes the point, a fair point, that the absence of GSR does not rule out the deceased did not fire a gun. Now, Ms Shaw is plainly right to make that point. Now, the obvious counterpoint being that the absence on GSR on the appellant's hand likewise does not mean that he did not fire a gun. And that's a point that, in my submission, would not have been lost on the jury. But for present purposes, looking at her evidence, it is important to appreciate that Superintendent Hibbert's statement was not before the jury, and the statement relied on by Ms Shaw was not, in fact, his evidence that was heard by the jury. His evidence was that you would expect to find GSR on the hands of someone that fired a gun. That's at 284. And the jury would have understood this to mean either the appellant or the deceased. And that is an uncontroversial statement, and one that the defence quite properly explored with Miss Dunbar, who carried out the actual GSR analysis. And the board yesterday were given the references, they're set out at paragraph 13C of our printed case, where Miss Dunbar was cross-examined with a view to demonstrating that the absence of GSR on the deceased's hands and clothing did not necessarily mean that she did not shoot herself. And I won't repeat those references that I gave the board yesterday. As to the point about this being the central plank and Lord Hope's question, we do say handwriting evidence, central plank. We say and accept that the Crown referred to the absence of GSR on the deceased's hands as significant, and that can be seen, the judge repeats that in her summing up. But given Miss Dunbar's evidence and also other passages of the judge's summing up, the jury would have been left in no doubt in my submission that it was not possible to deduce from the absence of GSR on the deceased's person, hands, clothing, whether she had or had not shot herself. And as to this, the jury were reminded in summing up of Miss Dunbar's evidence, namely that poorly taken swabs could affect results. That's at 1557. That's a reference to this in the summing up. And the jury were reminded that wet blood and moisture from the morgue could affect GSR at 1560 to 1561. There was some discussion yesterday, I think prompted by my Lord Legate, as to evidence of GSR absence on the appellant's clothing, and the board were referred yesterday to, I think, 1553 lines 13 to 14.
No, the point I was raising was whether the point was made that he didn't have it on his hand.
Absolutely, my lord. And you were taking 1553 lines 13 to 14, which is a reference to clothing. Prior to that passage, the jury were reminded that no GSR had been found on samples taken from the appellant's hands. So if one looks at 1550 line 23, 1551 line 3, this is the judge going through the samples that were analysed, and that reference I've just given, they are the samples taken from the appellant's hands. And then at the conclusion of that section, having gone through all of the samples, at 1553 lines 6 to 8, the reference is made, so none of those things recorded any presence of GSR. Now, none of those things is a clear reference to the samples that have just been listed, which include the samples taken from the appellant's hands. So there is the judge reminding the jury then no GSR on the appellant's hands and also no GSR on the appellant's clothing.
So things were said, but I don't want to take you out of context because we'll come back to the summing up. But immediately after that, we get to the passage at 1553 to 1554, where it said that the Crown's that she understood the Crown to be saying was that you'd have expected to find gunshot residue on her hand or garments, and they're saying the absence is significant.
My Lord, I accept that it would have been better had the judge more explicitly reminded the jury that a lack of GSR on the appellant's hands supported his defence.
Because the whole GSR question on your approach was completely neutral.
My Lord, yes.
And that isn't the impression that the judge gave to the jury.
Well, Lord, as I said, I accept that the judge could have, having made the point that the prosecution say the absence of GSR on the deceased is significant, the judge could have then followed that and said, and also remember, the defence say it is significant that there was no GSR found on his hands as well.
Thank you.
But my overarching point there is that is a point that simply would not have been lost on the jury. Having heard the evidence, and I take Lady Rose's point that you can't simply say, well, the jury heard the evidence when that evidence was heard 10 days before the summing up. But this was, to use the expression was used yesterday, it's a narrative style summing up. What the judge certainly cannot be criticised for doing is not going through all of the evidence in nearly minute detail. And the judge, in so doing, goes through Miss Dunbar's evidence as to the absence of GSR found both on the appellant and the deceased. And so the jury would have been reminded of that, and then would have been reminded of Miss Dunbar's evidence that she gave.
I think the main criticism of the summing up is that although it was a narrative summing up, it wasn't entirely narrative. And all the circumstances pointed out to the jury from which they could draw an inference were circumstances favourable to the prosecution. And I would be interested to hear what your answer is to Lord Hodges' point that when invited to point out some circumstances which favoured the defence, the judge declined to do so.
Well, perhaps let's deal with that.
We'll deal with that when you come to it, perhaps. We better not take you out of order, but if you can mark that as something that I will be returning to.
My Lord, yes. The third point on this being said to be the lack of GSR, said to be the central plank. Now, I made the point yesterday that the appellant relied on the absence of GSR on his hands in support of his defence, and I gave my lady and my lords, the reference to 984 to 990, which, as my Lord Hub properly pointed out, that's a reference to the no-case submission, so wouldn't have been heard in the jury's presence. It is a point that we can be almost certain would have featured in the defence closing. And as already submitted, insofar as the jury considered lack of GSR on the deceased's hands and night rest, they could have only concluded it offered them no assistance. And the final point, just on the fresh evidence, Miss Shaw's evidence, and it's a point I think I made yesterday. Miss Shaw accepts that the presence of GSR on the deceased's night dress was unlikely to assist in determining whether her death was self-inflicted, and she makes that point at 2.111. And that, in my submission, underscores the fact that the GSR evidence was never going to be of any assistance to the jury in their factual deliberations. I've addressed the reliability of the GSR testing methods. If I move then to Mr Mastaglio, so this is the new ballistics evidence. He draws 4 conclusions in his evidence, and the appellants have set those out in paragraph 55 of their case, which is 2269. I'll just briefly take each of those in turn. First, wound ballistics. In my submission, the jury would have been only too aware of the position of the body, the location of the gun, the height of the bullet hole. They had the photographs and they had the evidence of the height. They had the pathology evidence that this was a close contact wound. And they had the defence point that these were all more readily explained by suicide. So on wound ballistics, Mr Mastaglio's evidence does not therefore advance matters. The second point, no firearms evidence of third-party involvement, or rather probably second-party involvement. This again is stating something that the jury already knew. There was no suggestion by the Crown that there was any forensic evidence placing the appellant in the bathroom when the deceased was shot. The third point Mr Mastaglio makes is that the scene ought to have been examined by an expert in trajectory reconstruction. Well, the first point in response to that is the pathology evidence made it clear that the bullet travelled upwards, backwards and to the left. And this combined with the bullet hole, which was 2 feet 8 inches off the ground, that indicated the trajectory of the bullet. The second point is Corporal Mitchell's evidence was that trajectory rods could not be used because the bullet did not travel through the door, but effectively got lodged in the cavity between the front panel and the back panel of the door. As to that, Mr Mastaglio doesn't specifically comment on that evidence that was given by Corporal Mitchell. Now, even if further trajectory analysis could have been carried out, it wouldn't have offered the jury, in my submission, any more assistance than the pathology evidence combined with the position of the bullet hole in the door. So again, on that, his evidence doesn't take the matters further forward. And then the final point he makes, fourth point, is that the deceased could not have been standing upright when she was shot. Well, this again would have been a point the jury had, taking into account the photographs and the position of the bullet hole. So in summary on his evidence, the ballistics evidence does not cast any doubt on the safety of the conviction. And then turning to Miss Leake, blood spatter, she makes 5 conclusions in her evidence, and the appellants have set those out at paragraph 56 of their case, which is 2269. Again, briefly take each of those in turn. She firstly says, based on the photographs, suicide is more readily explaining the deceased's death. The board have my answer to that already. That is a point that the jury could determine for themselves, looking at the photographs that they had with them in the jury room. From those photographs and the conclusions that the defence invited them to draw from that evidence, so again, blood pattern, trajectory, position of the body, location of the gun, height of the bullet hole, the jury obviously rejected that and found, in my submission, as they were plainly entitled to do, that the appellant shot the deceased and staged it to look like suicide, based on the handwriting evidence. The second point that Miss Leake makes is the lack of blood on Mr Edwards. Again, same point, the jury would have been well aware that had blood been found in Mr Edwards, they would have been told about it. Corporal, I think it's Corporal Stewart's evidence was that he would have made a note had the appellant had blood on him. That's page 100, line 6. Ms Leek, thirdly, says that blood pattern seen on the deceased's hand is consistent with her holding a gun. Now, that is a point that the defence could have made had they wished to by reference to the photographs. And now we haven't got the defence closing. I don't know if that is a point that was made, but it was a point that was open to them on the photographic evidence. And the fact is, like all of the forensic evidence, it is equally consistent with a staged suicide as it is to the deceased shooting herself in my submission. The fourth point Ms Leek makes is that there was minimum space in the bathroom for someone else to have been present. It's a point that was relied on heavily by the defence. In my submission, it was made in the defence half-time submission. It would have featured in the defence closing. The jury, importantly, visited the scene, and several times during the summing up, the judge reminds them of the size of the bathroom, and in the next breath says, "But you will have seen this and be able to assess this yourself, having seen the locus in quo." In fact, Detective Corporal Mitchell's evidence, because he was asked about this, he said that it was possible for two people to be in the bathroom, was his evidence. But again, that's a matter that the jury would have been able to determine for themselves.
When you say these are matters that the jury could have worked out for themselves, isn't it nevertheless important that one has an expert in blood splatter coming along and saying, if the evidence had been there, to the jury, that in my opinion these findings can collectively be far more readily explained if the defence hypothesis were to be true rather than the prosecution hypothesis? I mean, the fact that the jury could have taken these matters into account isn't the same as saying, well, this expert evidence isn't of great importance, is it?
My Lord, when it comes to Miss Leek's evidence, I do say, with the greatest respect of her, she is not. Had this evidence been given at trial, it is not evidence that would have had any great moment as far as the jury is concerned, given the conclusions that she's reached. So take, for example, the minimum space in the bathroom. That is a point that the jury saw for themselves.
The critical point to my mind is the last one, is to her position when she was shot, and to the fact also that the body had not been moved from that into that position, because that was apparent, for example, from where the blood on the floor, according to the expert, matched the blood on her head. That meant that she'd been shot in that position with her back to the door, and that she hadn't moved from that position until the door was opened, allowing her to fall out. It seems to me impossible for him to have killed her consistently with that.
Well, my Lord, and that would have been the submission made by the defence in closing, and there was evidence. Well,
is there any answer to it? I mean, if that had been, we're considering the safety of the conviction ultimately. Is it possible? Is there actually a theory even which is consistent with Miss Leek's evidence, if it's accepted?
Well, my Lord, there was
as to how she could have been shot inside the bathroom with her back to the door, and the door not opened until it's then open for her to fall out. I mean, he couldn't have got out of the bathroom, and then it's just impossible.
Well, my Lord, that would have been something the jury.
Well, is it? I mean, does the prosecution now have any suggestion as to how it could have happened?
My Lord, I'm not in a position to sort of speculate as to how that could happen.
Well, the prosecution had to speculate, didn't they? They do have to speculate if we're to conclude that this conviction is capable of being upheld. If they don't even have a possible explanation.
Well, my Lord, the possible explanation is that the deceased was shot inside the bathroom by the appellant, and
sitting on the floor in the left-hand corner with her back to the door.
Well, yes.
And then.
How does he get out?
How does he get out?
My Lord, he would have to open the door, ensuring that the body remains in a seated position, stepped over the body and closed the door.
And all this without having any blood on him when he walks into the living room either seconds or minutes later?
Well, there is no evidence, and that's, I'm not giving an obtuse answer. I'm saying that it is right to say that this was initially treated as suicide and not homicide, and the police evidence on this came from one person who said that he couldn't find his notebook, but had there been blood on the appellant, he would have made a note on it.
Of course he would. And what about the mother, the deceased's mother? I mean, she hears a bang, and then a little while later, we don't know exactly how long later, Mr. Edwards comes into the living room. I mean, if he'd been covered in blood, you'd think she would have remembered that, wouldn't she?
But my lord, I mean, again, there's no evidence that he would have been covered in blood had he been the shooter. And going back to the, if I'm invited to sort of hypothesise on behalf of the prosecution, then the shot would have happened inside the bathroom. Yes. Keeping the body in a seated position would not have necessitated, given the position of the bullet hole, would not have required him to get blood on him by handling for example, the shoulder of the deceased to maintain a seating position. And then he steps out of the door, closes the door behind him. And it is then only his evidence that we have as to him opening the door, because the deceased mother doesn't see the opening of the door and the body falling out. It is only his evidence that is he opened the door. And
no, but that's where Ms Leake comes in, because her evidence confirms that the body has slumped to the floor in that position.
But that evidence, my lord, was also before the jury at trial. It's not Miss Leake, and I make the point again. She's, with the greatest respect of her, she's not bringing anything to the jury's attention that they would not have been aware of, because Detective Corporal Mitchell was extensively cross-examined about this, and in fact, you have the references. I don't know if my lords have my learned friend's note that's been provided this morning, that Lord Hodge asked for. But when one looks at the second page of that, where they go through the cross-examination of Detective Corporal Mitchell, he is asked if the door was closed after being opened, there would be some indication on the crime scene, and he said yes, page 218, line 20. If the person resting on the door and the door is open, the body would move. I would agree with you. So the points being made by Miss Leake were points that were put to the Crown witnesses. Certainly, really, Detective Corporal Mitchell was the one where they made these points.
But what about page 2093, for example, if I could ask you to take a look at that? 2093.
Well, yes.
Showing patterns of blood that indicate that the door was in a closed position when at least some of the arterial type projected spatter patterns were produced, and then you see the direction, change in direction in keeping with her head collapsing to the floor while the blood runs were still wet, causing the runs to change direction.
Well, by the way, even on the prosecution theory of the case, there wouldn't have been a suggestion that the door was open when the shot was fired.
No, but it's a difference between the door opening almost immediately after the shot was fired for him to get out of the bathroom, and the door opening sometime later after he'd spoken to the mother and come back. Isn't her evidence more consistent with the door only having been opened after the arterial blood had stopped spurting?
My lady, with respect, I don't think Miss Leake's evidence goes that far, given the time frame we're dealing with, which on any view is a short period of time. It's
a pretty bold submission to say that it wouldn't. there's no real likelihood it would have made a difference if the jury had had an expert to explain these points to them.
My Lord, with respect, I disagree, because I do say that these are, again, with great respect to Miss Leake, these are points that the jury were able to see for themselves on the photographs, and the defence brought to their attention through their cross-examination, certainly of Detective Corporal Mitchell, and in the defence closing. And the jury would have weighed all of these points up, and the sort of impossibility argument. And in finding the appellant guilty of murder, they must have obviously rejected his evidence that he didn't write the suicide note, did not therefore shoot the deceased. And whilst there are a number of points that could be made, as are being made to me now, as to why the forensic evidence and the photographs are more in line with suicide, these were not such as to generate doubt in the mind of the jury, who had the handwriting evidence in front of them.
But is your point that blood spatter evidence is really useful when you don't know from where the bullet has been fired? But here, we know that the bullet was fired with the gun right against her head. But it is still useful with regard to the movement of the body.
Well, I certainly I accept what your ladyship says, and I accept the second proposition as well. In this case, trajectory, position of whether it's suicide or murder, position of the gun, the jury knew that from the evidence. Blood spatter goes to really the movement of the body, and that is something that I say the jury would have been able to see for themselves based on the photographs. So, for example, there was no blood outside the bathroom. The defence were making the point that the door had to have been shut, and one can imagine the point being made, as my Lord Legate made to me, fairly forcefully by defence counsel when standing in front of the jury. Well, how does the Crown say that my client shot the deceased?
Well, it seems to me the cross-examination of Detective Corporal Mitchell is quite important, because, as you say at page 218, line 20, he says, he accepts that if the door had been closed after it had been opened, there would be some indication on the crime scene. He accepts that. And no evidence has been produced by reference to the photo or otherwise that there was any such indication.
Well, no, that is right, and that is not simply a point the jury would have had from hearing that cross-examination. It's a point that the judge reminded them of in her summing up.
Well, we'll come to the summing up later, yeah. But it's quite a significant point.
Mr. Paul, suppose that Mr. Leake had been a witness at the trial, and she'd given evidence in accordance with her statement, and we can see at 2094 what her opinion and conclusions were. What are the principal questions you would have put to her if you'd been the Crown advocate rising to your feet to cross-examine her?
That she wouldn't have been able to rule out the fact that the appellant could have shot the deceased and left the bathroom without there being any indications by reference to blood spatter.
Right.
And once that is put and accepted, then I'm not entirely sure I would have taken much longer with her, because that's really the core of her evidence, because everything else, as I say, is there to be seen from the photographs.
I mean, the highest the contrary goes is to suggesting there might be a reasonable doubt that she didn't commit suicide.
Well, my Lord, obviously no. So when you look at all the evidence together, obviously
Well, I mean, all you've got against that, or had against that's a handwriting evidence, which is A, taken by what's agreed to be an unsatisfactory technique, and B, contradicted by another expert who says you can't draw that conclusion from it.
Well, my lord, I'll come. Ground three is that I don't accept. I don't accept my lordship's. Well, I accept the summary of the points. I don't accept the validity of those points. And ground three is an important ground in my submission, because if this board is persuaded that the criticisms made of the handwriting evidence are bad, then that, in my submission, is the answer to this appeal, because that evidence was then properly admitted, and provided it was properly admitted and properly summed up by the judge, then for this board to effectively go behind that and act on what would be, in my submission, akin to, using the language of one of the cases, a judicial hunch, would be wrong.
Surely that is to push the Lau line of authority into a fresh evidence case.
Well, no, only if you're, as it were, against me. If you're admitting the fresh evidence and are say, well, no, Mr. Poole, you're wrong. We think this fresh evidence, had it been given at trial, would have had some effect on the jury. Then I accept we're not in lurking doubt. We're in Pendleton, Stafford territory, and the question being, does it cast doubt on the safety of the conviction?
I mean, your case, as it seems to me, is rather like the way the Court of Appeal put it at page 1 of their judgment, that the principal question is, do you accept the evidence of Mr. Major? If you do, that's the end of the case, because the author of the suicide note must be the killer, whether it's suicide or murder, and that's all you need to know, and the rest of the evidence doesn't matter one bit. And questions such as my Lord Hodge put, how on earth did he get out, are just irrelevant, because the handwriting evidence is conclusive.
Well, not irrelevant, but are of less significance in my submission, because the jury must have accepted the evidence that Mr. Major gave, that the appellant wrote the suicide note. And then the defence points as to impossibility would have had less significance, or would have been viewed in light of the acceptance that he wrote the suicide note.
Well, the problem is you can't logically proceed like that, can you?
Look, I accept that the jury have to consider, obviously, all of the evidence, and we can't second-guess what would be in the minds of the jury. But given the evidence and given the conviction, we can assume they obviously accepted Mr. Major's evidence, and in so doing, they would have rejected the appellant's evidence that he didn't write the note and he didn't shoot the deceased.
Yeah, but they'd also have to, I mean, you don't just start with a handwriting expertise and then reach a conclusion on that. What the judge is telling them is you've got to look at it all together. And whether you accept the handwriting expert evidence depends on facts like whether he could have got out of the bathroom.
But this is the risk or danger at this far removed. The jury went to the property. They would have individually, one assumes, gone into that bathroom and closed the door behind them, each one of them assessing the likelihood or not of the event happening as either the Crown or the defence suggest it did happen. The jury would have had to have satisfied themselves that it was possible that the appellant murdered the deceased, obviously, because had they determined otherwise, it would matter not what Mr. Major said.
But the point, is this the point that everyone can look at the photographs and see the blood spatter, but somebody has to explain what the significance of it is. You can all see it, But as a layperson, you can't really look at you can't really understand what it is you're seeing or the significance of it unless somebody explains it to you. And the question is, you say, well, the defence explained it to the jury and the judge explained it. And perhaps the question for us is, might it have made a difference to the jury if a blood spatter expert had explained it to them, someone who has expertise in this, rather than counsel for Mr Edwards explaining it to them? Is that where we get to?
Well, I think that's a fair way of putting it, but then one has to ask whether having Miss Leake explain the evidence would add anything to the explanation given by the defence and the defence hypotheses and the judge. And in my submission in other expert disciplines, then I can see the answer to that may be, well, yes, it does, because, for example, gunshot residue, the defence, arguably without if gunshot residue had been found, you can carry out analysis of whether it's the number of particles are found. That requires expert evidence. The evidence that Miss Leake gives doesn't, in my submission, take matters any further than the defence were able to put in closing, and the judge.
No, I understand the point. What I'm exploring now is whether, as I say, that an independent person, albeit called for the defence, who is an expert on these things, are explaining, well, look, you see this spatter, this is because of arterial blood, and you can see the blood on her face changing direction, that might have had more, that might have been more powerful for the jury than counsel.
I would accept it if an expert opines on something exclusively within their expertise, then that would obviously carry more weight than if counsel simply says, well, in my view, this is the position. But here again, and I'm apologising.
Yeah, no, I understand. I understand what you're saying.
She is really saying
that you can look at it and form your own view to an extent. Yes, I understand your case. I'm just putting the point to you.
As to the remainder of ground one, which is lurking doubt, so that's dealing with the fresh evidence. The appellant's argument is also that even without the fresh evidence, this is a lurking doubt case, and they set out at paragraph 58 of their printed case, which is 2270, why they say that. And we have responded in our case at paragraph 19, which is 2311. And there are 10 matters that are listed or by the appellant, such as, and I'm not going to go through them, but such as there being no evidence of blood or GSR on the appellant, no sign of a struggle, matters like that. And the board has my submission in response to that, which is these are all matters the jury would have had well in mind, having heard the evidence and the defence closing and the summing up. They are matters that were raised before the Court of Appeal, and they're dealt with by the Court of Appeal at paragraph 8 of its judgment, which is 1913 to 1914. And the question that I submit the Court of Appeal properly asked itself was whether the issues of fact were properly placed before the jury. And in my submission, when one reviews the summing up, that supports the Court of Appeal's conclusion that the issues of fact were properly before the jury. It's not one of those exceptional lurking doubt cases where it can be said that the jury's verdict was obviously and plainly wrong. There are four specific points that I've probably not dealt with already, and I'll just deal with those. The first is lack of time to stage the scene to look like suicide. I think we've touched on that this morning. And my Lord, Lord Bean has the point, and we discussed it yesterday, about there not being any evidence as to the precise amount of time between the shot and Mrs Harris being alerted to the shot and the appellant appearing in the living room.
Well, it was obviously very short. I mean,
I don't...
on any, just as a matter of common sense, it must have been.
Absolutely, my lord. And you have I think I gave the board the references yesterday. There was a point made in cross-examination about the difference of the appellant in his interview and what he said about initially saying he walked and then walked briskly, turned into I rushed, and he was cross-examined about that. But the short point here is that the length of time, and I accept admittedly a short length of time, would have been something the jury were clearly well aware of. The second point is Mrs Harris's dream. Now, the fact that there was reference to Mrs Harris's dream in the suicide note obviously is explicable by the deceased having told the appellant about the dream and having the ability to do that in the time they had together from him arriving and the suicide or murder. But the jury were aware of the dream. They heard Mrs Harris's evidence, and I think it was suggested by the appellant yesterday that the dream was simply omitted from the summing up. That's not right. There is reference to the dream made in the summing up. It's 1478, and then again it's 1648, the latter reference being the jury being reminded that the dream was not investigated by the police. The third point is made about lack of motive. There was a lot of evidence before the jury as to the deceased and the appellant having never been seen to quarrel. Mrs Harris said that she'd never seen the deceased and the appellant quarrel either before or after the deceased's marriage to someone else. Miss Johnson said the same, so the jury would have had that evidence in mind. It was reminded in the summing up again, and the judge reminded the jury properly that the Crown is not required to prove motive. That's at 1785 of the summing up. And then finally, the handwriting expert evidence, but I propose to come to that when dealing with ground 3. But for all of those reasons, either with or without the fresh evidence, I say this, there's nothing in ground 1. Ground 2, I think I can take fairly quickly, because we've covered some of the ground already when looking at delay. Ground 2 is the contention that failures in the investigation, such as cleaning of the crime scene and destruction of evidence, gave rise to a miscarriage of justice. So irrespective of delay, in and of itself, gave rise to a miscarriage of justice. Now, our overarching submission here is that, yes, there were certain failures to adhere to best practice in the investigation, and it's certainly unfortunate that evidence was inadvertently destroyed prior to trial. But the suggestion that injustice has been caused by such failures is speculation and impossible to sustain in my submission. Having regard to the principles derived from the Ibrahim and the Queen and RD that we looked at yesterday, the board really is considering what evidence directly relevant to the case has not been gathered or has been lost, the importance of that evidence, and then what prejudice, if any, has been suffered by the appellant. Now, there's 5 specific complaints made by the appellant in their case, paragraphs 62 to 66. And as I say, some have been dealt with already when looking at delay, so I deal with them briefly. The first is the GSR investigation. The board has heard what I've said, what I have to say about that already. Second, blood spatter investigation. Again, board got my submissions in that regard. I do say it is speculative that any further blood spatter analysis would have provided, to use the words of Lord Justice Treacy in the Queen and RD, decisive or strongly supportive evidence for the defence. Same in respect to the ballistics investigation. The fourth point, other matters at the crime scene. I think it's suggested by Miss Leake that the suicide note ought to have been tested as to the for fingerprints, which would have supported the defence case of suicide. Well, same points I've made in respect of the gun. The suicide note was written in one of the deceased's books. Finding the deceased's fingerprints would not have been unexpected in the circumstances in my submission, would have given very little, if any, assistance to the jury. And then destruction of evidence, the board has heard what I've said about that in the delay submissions. So in short, whether ground 2 relies on fresh evidence or not, I say there's again nothing in it. And the Court of Appeal will reach the conclusions that it reached in respect of the investigation alleged failures.
The pen which had been used to write the note, was that available?
It certainly wasn't gathered in evidence, my lady. Move then to ground 3.
So just one other point. I mean, was there any evidence as to the time between the shot having been heard and the arrival of police? Do we know?
We know that I think Sergeant Brown was the first responder, and we do know, it's set out in the chronology, that she arrived at about 11:50, and the reference to that 2159, 2161, which is her statement in the supplemental record. And the timing of the deceased being shot is put in the chronology at 11 a.m. Now, that's an agreed chronology, and I can find the basis on which the parties have been able to agree that timing. If there's
So about 50 minutes?
about 50 minutes is...
Yeah. Thank you.
And was Mrs Harris with the she fainted, didn't she? So, but was she with the defendant from the time that they saw?
I think there's some evidence that they waited in the living room, but I don't think there's any evidence as to whether they were together for the entire period between the shot being heard and the police arriving. There are three sort of aspects to the ground 3 complaints, and the ground 3 complaints really go to the handwriting evidence. The first, it is said that Mr Major's handwriting ought to have been excluded because it was plainly unreliable. Second, it said that the appellant suffered prejudice by virtue of the judge's inadequate directions regarding Mr Major's evidence. And third, it said that the appellant suffered prejudice by virtue of the judge's directions in respect of Mr Hayward's evidence. And I'll take those 3 points in turn. As to the admissibility of Mr Major's evidence, I submit the complaint should be given fairly short shrift for simple reason. No application was made at trial for the evidence to be excluded, and as such, certainly the judge cannot be criticised for allowing his evidence. Mr Hayward was sent the handwriting evidence on the 17th of October 2016, and we see that the reference for that is 11:53, lines 7 to 8. And his report is dated 27th of January 2007. And you've got that at 2:17. Sorry, my lord.
27th January 2017.
My lord, yes, you're quite right, obviously. So, thank you. 27th January 2017, that's at 2217. The defence had more than ample time to determine whether there was to be any challenge in my submission to Mr Major's evidence. And given the significance of Mr Major's evidence, the board, again in my submission, can rest assured that if there was any reasonable basis to have his evidence excluded, this would have been attempted by the defence. As to the points that are now being taken as to admissibility, basically because it's based on reliability, I submit they should be given also very short shrift and are without merit. Really, there's two reasons. The case of Robinson that Mill and Friend took you to makes it clear, and this is 2787, paragraph 20, you're taken to Lady Justice Smith's judgment. Reliability as a basis to exclude evidence is a very low threshold. And so if the evidence is such that a jury properly warned could place some weight on it, then it should be admitted. And I submit that is plainly the position here. But the second point is, I say the appellant is simply wrong to contend that Mr Major's conclusion was based on a fundamentally flawed process. And I submit, when one looks at the evidence, that does not withstand scrutiny. And the submission is founded on a contention that Superintendent Phipps actually instructed the appellant to copy the suicide note. And based on this, the appellant now questions whether the samples of the appellant's handwriting that were taken were in fact genuine or natural handwriting. So that's the basis of the appellant's contention. And I make 3 points in response to that. First, I say it is clear from the evidence that the appellant did not simply copy the style of writing on the suicide note. He was instructed to copy the words written on the note. Now, I don't dispute that it is best practice for specimen handwriting to be collected by dictation. That was the position of both Mr Major and Mr Hayward at trial. And the obvious reason for that is so that the specimen handwriting doesn't simply copy the writing in question. But in the present case, although the appellant was not, the note was not dictated to him, he was given the suicide note so that he knew what words to write. I do say he wasn't instructed to simply copy the style, and we see that from Superintendent Phipps's evidence in cross-examination. It's 648, where he told the appellant to write the words on the note. And he later says at 649, lines 17 to 18, I told him to write the words not as it was in words. In other words, the appellant was told to write the words, not to copy the style in my submission. That's the plain understanding of what Superintendent Phipps was saying. Now, this was also confirmed by the appellant. He stated that Superintendent Phipps told him to write 5 script and 5 in my natural handwriting. That's 1115, lines 13 to 16. And he later states, Superintendent Phipps said, and this is 1116, lines 9 to 11, me never tell you to copyright it in your own handwriting. So in other words, again, this Superintendent Phipps' instruction being not to copy, but just to write the words. And I do take the sort of point, the appellant clearly understood at this juncture that there was an investigation into the deceased's death, and the purpose that he was being asked to provide this sample. It is inconceivable in my submission that he would have simply copied the style of handwriting on the suicide note. Yeah. But the second point is, so that's the evidence as to how the samples were generated. But the second point is a point that was noted by the Court of Appeal. Mr Major described the appellant's sample handwriting as free and flowing, boldly written handwriting. That's at 939, lines 8 to 9. He also, later in his evidence, described it as free and flowing cursive writing. It's 940, lines 13 to 14. And then at 943, he described it as a mixture of writing styles. And Mr Hayward's evidence, and this is the third point, was also that the appellant's specimen handwriting samples had been executed, his words, with speed and naturalness. And we see that in his report. It's page 2220. And he also noted that there was no evidence of hesitation or distortion in respect of the specimen handwriting samples. So the fact that both experts found the appellant's sample handwriting was free-flowing and natural underscores in my submission that this was plainly material that should properly be considered by the jury in determining whether the samples that Mr Major analysed were a true representation of the appellant's handwriting. It was suggested yesterday that Mr Hayward's evidence supported the contention that Mr Major's evidence was unreliable as a consequence of being founded on flawed methodology. Now, it is, of course, right to say that in his report, a report that was not before the jury, but in his report, Mr Hayward did say, consequently, a definitive conclusion of elimination of Mr Edwards was not possible, and the board had the reference to that yesterday, 2222, that's his report. But it's important to understand what he was saying when he said consequently. He was there referring to not being provided with course of business specimen handwriting, i.e. documents written by the appellant in the course of business as opposed to sample handwriting. And he explained what he meant by course of business at page 1170, lines 17 to 20. He gave examples of writing cheques or writing a diary. That is a very different complaint as to methodology to the one that the appellant makes to the board, which is that there are doubts that the sample handwriting was in fact Mr Edwards, a true representation of Mr Edwards' handwriting. And when he gave evidence, Mr Hayward did say that a writing sample should not be allowed, writer of a sample should not be allowed to see the question or disputed writing. He said that at the very start of his evidence at page 1164. There was no link, though, in his evidence between that statement and his conclusion that the appellant couldn't be eliminated, which he gave at 1198. So, in respect to this first point on ground 3, we call it admissibility or reliability, in my submission I say the judge was correct to admit Mr Major's evidence. The appellant is wrong to suggest that Mr Major's analysis was based on a fundamentally flawed process. Turning then to the second and third complaints, which concern the judge's directions. Now, the first point to note here is that Mr Major was subject to, as I think we discussed yesterday, a fairly extensive cross-examination, during which a number of criticisms of his evidence and methodology were put to him. And the reference to cross-examination is 843 through to 907. Just by way of a few examples, Mr Major was cross-examined about not using enlargements during his analysis at 850. He agreed that a careful study of standard writing should be carried out before the questioned writing. That was at 892.
Does standards mean the same there as course of business?
Yeah, well, that's my understanding of his evidence, yes. He agreed that you should dictate text to get a sample at 937. And then at the end, he agreed that there had been no peer review of his analysis at 964. So the jury were aware that reliability of his analysis and methodology was an issue, and were in a position to assess for themselves the quality of his evidence when they then heard Mr Hayward's evidence. And when it came to summing up, the judge gave entirely proper directions to the jury how to treat expert evidence generally, but also reminded them of that direction when looking at the handwriting experts. And if I can give the board the reference to where I set out the references and summing up in our printed case rather than running through them now, it's paragraph 14E of our printed case, which is 2310. And I've set out there 4 references to the summing up. The judge then, in my submission, gave a clear and balanced account of the handwriting evidence itself, dealing first with Mr Hayward's evidence and the defence position, and did so at some length, 1745 through to 1762. And specifically, the judge reminded the jury that Mr Hayward's opinion was that the appellant was not confirmed as the author of the suicide note, and that the person who wrote the contents of the notebooks could not be excluded as the writer of the suicide note. And draw the board's attention to those directions there, 1781 to 1782. So, in my submission, I submit the Court of Appeal was right to hold the judge fulfilled her duty in respect of this aspect of the case, and carefully placed the jury, the issue rather, in dispute before the jury. And what is said at paragraphs 106 to 108 of the Court of Appeal's judgment is a complete answer to the present complaint. That's 1953. I mean, the short point was it's for the jury to decide which, if any, of the expert opinions they would accept.
Did the judge give any directions to the jury about the flaws in the methodology? And she certainly said, you've got Major, you've got Hayward. This is what Hayward said. You've got to treat them like any other witness and so on. But did she say there are matters of concern which Major has accepted to some extent about the what he should have done?
Well, I'll find the reference. There's certainly a reference in the summing up to the judge reminding the jury about best practice, being dictation rather than copying. But if I haven't got that note in front of me, but I'll find that and give that to your lordship, if I may. Moving then to ground 4, which I can deal with fairly briefly. This is the appellant's police interview, and my overarching submission in respect of this ground is it ought to be rejected as clearly unfounded. There's an admissibility complaint, firstly, and again, I make the same point as I did for Mr Major's evidence. There was no complaint by the defence at trial about the police question and answer interview being admitted in evidence. There's no basis, therefore, to criticise the judge in this regard. The real complaint is that some of the questions that were asked in that interview consisted of police theories about the killing being motivated by jealousy. But in my submission, the Court of Appeal was entirely correct to firstly note, obviously, that the police questions did not constitute evidence, and also to note that it would have been better had the judge expressly directed the jury as such. However, as already submitted, the jury heard evidence from Mrs Harris and the deceased's niece as to the good relations between the appellant and the deceased. There was also evidence given by Inspector Craig Minnett to that effect, and the judge reminded the jury of that evidence in her summing up, as well as the appellant's evidence as well of the continued good relations between himself and the deceased, and the fact that they maintained those good relations despite the deceased's marriage to another man. Those references to the summing up in 1941, line 86 through to, that can't be right, it's 1941 through to 1942. And it's for those reasons that the Court of Appeal didn't consider there was any miscarriage of justice as a result of the police question and answer interview being admitted into evidence, and the judge's summing up on that point, and I submit the Court of Appeal were entirely entitled to come to that conclusion. I invite the Lordship, my Lady's Board, to come to the same conclusion. Moving then to grounds 5 and 6, which I take together, which relates to the summing up, and the Board will have heard some of my submissions on this already. There's really 3 complaints that are made about the judge's summing up. First, it is said that the judge failed to summarise the defence case. Second, it's said the judge uncritically summarised the Crown's case. And then third, it is said that the judge didn't adequately direct on delay. Now, for the reasons we've set out in our printed case, paragraphs 47 to 51, which starts at page 2322, submit that there is nothing in any of the complaints that give rise, certainly, to a material irregularity. If I can deal first with the complaint of failing to adequately summarise the defence case, and I think as I submitted yesterday in answer to my Lord Hodge's question, I do accept if a cardinal line of defence is placed before the jury and that finds no reflection in the summing up, it would in general be difficult to say that the conviction is safe. But I do submit that the present case is far removed from such a situation. And as I said yesterday, the cardinal line of defence here was that the appellant knew nothing about the shooting and the deceased had committed suicide. And the jury were reminded on a number of occasions of that defence. And I gave the board the references yesterday. They're set out in paragraph 14C of our case, which is at the top of page 2310. And as I said yesterday as well, the jury would have been well aware of the defence position in respect of each strand of circumstantial evidence relied on, having heard first the cross-examination of the witnesses, second the defence closing speech, and then third, defence counsel's request to the judge to give further directions. And you were taken to that yesterday at 1779, 1780. And obviously the jury would have heard the defence counsel's request for those directions and would have heard what was said.
Well, they heard it getting a brush off, basically.
Well, my lord, I say it's unfair to say that the judge dismissed those points. What the judge said is that they are all findings of fact that the jury will have to look at, which, in my submission, in fact, reinforced to the jury that they had to look at those points when deciding whether they could be certain that the appellant shot the deceased. So, far from being a brush-off, in my submission, it would have focused the jury's mind. They heard defence counsel say, well, there are these points that we say it is impossible. And then the defence counsel listed those points. And the judge then, to a certain extent, I asked the question, what if any, good would the judge simply have done? The judge would have repeated those points again for the jury. The jury had those points, and the judge, in fact, says, well, they are findings of fact the jury will have to look at.
Do you accept that that was part of what is said at 1779 to 1780 by Miss Netta Robertson, what was an important part of the defence case?
Absolutely, my lord.
Yes.
Absolutely.
Well, where do we see in the summing up any significant discussion of those points?
Well, what we see in the summing up is the points that are raised in evidence, the jury being reminded of those. And so, for example, the evidence relating to the bathroom, so its size and the fact there's no evidence of a struggle, the judge reminds the jury of that at 1514. The location of the bullet hole, indicating the deceased was likely seated when she shot, the judge reminds the jury of that at 1516, lines 5 to 7. The trajectory of the bullet, the judge reminds the jury of that at 1596. And then the lack of gunshot residue and blood on the appellant. The reference to none on his hands is the reference I gave earlier, 1553, lines 6 to 8, and on his shirt, 1553, lines 13 to 14. The note that the appellant produced overnight, the note on evidence, shows where certain points were, where the Crown's witnesses were either in chief or in cross-examination taken to a number of these points. And if I can, I don't know if the board, if it would be useful for me to do this on my feet, because obviously I haven't had, and this is certainly no criticism of Mill and Friends at all, I haven't had long with the note, but what I have sought to do, if I can just give the board some references. So Senior Superintendent Stewart's evidence, which is point 2 of, I'm looking now at their note. What I'd like to do is just give the board the summing up references, if I may, to where that evidence was summed up. It's 1482 through to 1491. As to little a, agreeing the bathroom was very small, 1487, line 2, is where the judge reminds the jury of that. Little b, 1484, lines 18 to 20, and then again at 1487, lines 19 to 20. Little c, 1489, line 25. Little d, 1490, lines 15 to 19. Little e, 1419, line 1 to 2. Detective Corporal Mitchell, his evidence starts at, being summed up by the judge at 1518. And again, I can move through, and it may be not terribly helpful me doing this on my feet, and it may be that I can add these references to our own version of the note. But the short point is And it probably will come as no surprise to my lord and my lady, given the detail of the summing up, that all of this evidence was summed up by the judge.
But that's not the point, is it? The summing up took how many days did it take? 3 days or something, and at least. And it's one thing to have a point here and a point there made at different times over the course of 3 days, but it's quite another to have it all collected so that you have to see that you've got to look at this combination of circumstances. And the judge did that when she finished dealing with the prosecution case, and she collected together the circumstances the prosecution were relying on, put them quite forcefully, and there was no counterpoint to that in the defence case.
My lord, again, with respect, I disagree in the sense of that the defence request for further directions listed out the points that the defence relied on for their impossibility argument. Had the defence counsel simply said, well, there's obviously the impossibility argument, that may have prompted the judge to say, well, right, what do you mean by that? What do you want me to direct upon? But in fact, defence counsel, in making her point, lists out the points. And I go back to the submission I made a moment ago. It would have served no useful purpose for the judge to then have said to the jury, you've heard what Miss Nita Robinson's got to say, and I will list those out again for you. That would have served no. I mean, all it doesn't have is, as I said yesterday, some judicial imprimatur. But the jury.
Well, they weren't spelt out. It was just a list. There's the height of the door. There's the lack of whatever it was. But that's one thing just to say that. But what she did for the prosecution was she went through over several pages, saying, and then you got this. She could have said, you know, the height of the door. That your defence asks you to consider, members of the jury. Infer that she must have been sitting with her back to the door, and then you have to ask yourselves, how could Mr. Edwards have fired the bullet with his left hand in that position?
But my lord,
that sort of thing.
But the defence case was a lot more simple, in the sense that the defence case was simply all of these things taken together are more indicative or point towards suicide rather than murder.
Yes.
And that the jury had, so the judge did not need, in my submission, to go through, as she did with the prosecution's circumstances, that level of detail. And in fact, when the judge did go through the prosecution's circumstances, she very fairly said there is this evidence, but also there is evidence on the other side. So it wasn't just a list of these are the prosecution's points. You should look at them sort of in a vacuum. She looked at the evidence that went both ways as to those 9 circumstances. Now,
well, in the Court of Appeal, the Court of Appeal set out the submission there, which you could assume was fairly similar at 1913-14, a list of 8 points. When I read that list of 8 points to myself, I thought, well, that's a pretty compelling list of circumstances. And if the judge had given a similar list like that to the jury, it might have made a very significant difference.
Well, my lord, I mean, as we discussed yesterday, I mean, one of them was the appellant should have been able to detect exactly where the bullet, where the sound of the bullet came from. I mean, there were... No,
sorry, I'm talking about the defence points that the Court of Appeal listed out, if you remember, in their judgment.
Yeah, I'm grateful. Well, my lord, don't get me wrong. I accept that another judge might have marshalled and, as necessary, analysed those points in a longer section of the summing up. But, however, on this case against this appellant, which was narrowly focused, it was sufficiently explained by the judge in my submission.
Well, but by saying those are findings of fact they will have to look at, but I've heard.
My lord,
that was all she said.
That's all she said there. Obviously, one needs to read the judgment.
You made the point that in the narrative of the evidence, reference were made to these things. But Lord Legate's point is, where is the pulling together of the evidence to show what the defence case in fact was? I mean, it seems clear that Mrs. Robertson was concerned that the defence case as to how, given the nature or the limited nature of the evidence and the absence of any evidence that someone had opened the door and shut it again, evidence that one would expect to have left evidence which would, I think it was Corporal Mitchell said, one would have expected to have seen some scene of crime evidence of that having been done. The defence were saying, well, how's this been shown to be possible? And if there's any doubt about it, they must acquit. I mean, it was alongside their unsuccessful evidence about handwriting, it was a cardinal point of their case.
My Lord, and had Miss Nita Robertson not listed those points when inviting the direction, and had the judge simply said, well, those are matters that whether this is possible or not on the defence case is a matter for you, members of the jury, then I may be in more difficulty. The fact that she has listed there what she obviously sees as the important points as to impossibility, I say there is absolutely nothing wrong on the facts of this case of the judge saying to the jury, who will have heard all those points, well, these are matters of fact, members of the jury, for you to consider, when having reminded the jury of the evidence earlier on in the summing up. But as I say, yes, I accept another judge on another day may have marshalled and analysed those points in the longer section of the summing up, but the failure of this judge to do so doesn't constitute a material irregularity on the particular facts of this case in my submission. The next complaint is about the way that the prosecution case was summed up. And if I can answer this by giving references to our printed case, where I've then listed references to the summing up. So at the outset, the judge properly directed the jury as to burden and standard of proof, and that it was obviously for the prosecution to prove guilt, and those are paragraph 14A of our printed case, 2309. I won't go through those references now. There was a reminder that the prosecution case was based entirely on circumstantial evidence, and critically that it was therefore very important for the jury to examine such evidence with care. Those references given at paragraph 14B of our case, 2309. And the judge reminded the jury of discrepancies in the prosecution's case, including what was clearly seen as an important discrepancy for the defence, that concerning Sergeant Brown's statement and Superintendent Phipps's evidence. And we see that at 1636 through to 1638. As to the 9 specific complaints that are made at paragraph 110 of the appellant's case, now some of those have been addressed already under other grounds of appeal, but if I can briefly just run through these. First is opportunity. And as I've said already, the jury would have the defence contention there was very little time for the appellant to stage a scene to look like suicide. So the judge's failure to remind the jury expressly of that cannot be said to render the conviction unsafe in my submission. Second, the appellants refer to an inconsistency regarding when the appellant was moving abroad. It's paragraph 110, Roman 2 of their printed case. The appellant says they don't understand the significance of the judge reminding the jury about this inconsistency in the evidence as to when the deceased as to when the appellant told the deceased he was moving abroad. Now, just for your lordships, my ladies, note the relevant passage of the summing up is 1676 lines 2 to 12. But in my submission, the point that the judge is making here was an entirely fair one, and in fact shows balance in the summing up. The appellant had given evidence that the deceased was feeling down on the day in question because he had told her that he was moving overseas for good. The defence case being that provided a potential motive for suicide. But having reminded the jury of the appellant's evidence in this regard, the judge is pointing out in that passage of the summing up that elsewhere in the appellant's evidence, he had said that the deceased already knew that he was leaving Jamaica because she had attended the embassy when he with him to collect his visa. So there's nothing objectionable in that passage of the summing up in my submission. The lack of gunshot, the third point is the lack of gunshot residue on the deceased's hands. The board already have my submissions on that. Fourth, the appellant not remembering where he put the firearm. Now, I submit the appellant's wrong to say the judge didn't remind the jury about passage of time impacting the appellant's memory. we've set out at paragraph 14D of our printed case, which is 2310, the relevant references. The judge directing the jury on more than one occasion that memories fade over time, and that is indeed a relevant factor when assessing witness credibility. You've got the reference 1463 to 1464, the general direction that this happened 10 years ago, human beings are not perfect, memories fade over time. You've got the reference at 1622 that having directed the jury on the difference between discrepancy and inconsistency, the judge then again directs to bear in mind that this happened 10 years ago. And then specifically on this point, 1740, lines 14 to 24, you've got a direction on the appellant's evidence about taking off his gun, not recalling where on the dresser he put it, and the judge reminds the jury of the initial direction about memories fading, and then says, he is saying that 10 years ago, you know, things of that nature might have faded in his mind. So the jury would have known for themselves 10 years memories fade, but then had specific instruction, proper directions from the judge as to the impact that has on reliability and credibility. The fifth point is the contradiction between the appellant's evidence and Superintendent Phipps regarding knowledge of the suicide note. I addressed the board briefly on this yesterday. The judge reminded the jury about this contradiction on more than one occasion, and so ensured the jury understood that Superintendent Phipps's reliability and also his credibility based on the cross-examination was clearly in issue. And we've set out the references at paragraph 49A of our case, 2323. I do submit the appellant is wrong to say that the judge failed to remind the jury that Superintendent Phipps's statement contained no reference to the appellant, pointing out the note to Sergeant Brown. The judge reminded the jury of that at 1636, lines 17 to 21. So based on those directions in my submission, the jury would have been in no doubt as to the task they were being asked to perform and the issues of fact they were required to consider on that issue.
But do you accept that what the jury were being told was that this went to the issue of whether the police witness was giving dishonest evidence, that he had fabricated this reference to being shown Sergeant Brown saying that Edwards had pointed out the note to her?
Lady, given the judge leaves that possibility with the jury, and also in my submission the jury would have also understood that it could be explained by the passage of time and memories fading over time and a more of a reliability point. But I think the reason the judge, in the summing up, emphasises credibility is because of the nature of the cross-examination that the jury would have heard, because it is put fairly starkly to the police officer that he is being dishonest and that he's playing games with the court. Sixth point, the allegation that the appellant should have known where the gunshot came from. The board heard what I had to say about that yesterday. The jury were properly directed not to speculate, and that any conclusions they arrived at had to be based on supporting evidence. Those directions are at 1499. I submit the jury would have had that well in mind when considering the prosecution suggestion that the appellant would not have run past the bathroom. Seventh point, the position of the deceased's hand. Again, the jury would have known not to speculate as to whether they could draw any inferences from the position of the deceased's hand. Eighth, the prosecution's theory of a staged suicide. The board already has my submissions on the failure to test the gun and holster for fingerprints and DNA, and why I say cannot have prejudiced the appellant in this case. And then finally, lack of motive for suicide. Again, the board have the point that the jury were reminded of the relevant evidence that the deceased was feeling down on the day in question. Contrary to what the appellant says, the judge also reminded the jury about the dream, Miss Harris's dream, and I gave the board the references to those passages of the summing up previously.
In the note, are Ivy and Peaches her sisters?
Children. They are the twin
No, I think the twins are called.
The twins are
deceased.
Have I got it wrong?
They're in the deceased.
They're sisters, the deceased. Oh, I apologise. I'm grateful from them, friend. Yes. Turning finally on grounds 5 and 6 then to delay. This is the third criticism of the summing up. And I can deal shortly with this. The law, as was set out in the Queen and M, which the board has at 2720, Lord Justice Rose, making the point that when it comes to delay, prescription by the appeal court as to the precise terms of a summing up is best avoided. And where, in my submission, as here, the evidence is cogent, a specific warning as to potential prejudice caused by delay might not be necessary, and its absence would not necessarily render a conviction unsafe. That's what I derive from the Queen and M. So, accordingly, whilst I accept the judge in the present case didn't give a direction in line with, for example, the Crown Court Compendium standard directions, that the directions that were given regarding delay, which I've already brought to the board's attention, were more than adequate, taking into account the cogency of the evidence and the manner in which the defence was conducted. The short point being, in my submission, there's nothing in the criticisms of the summing up that amounts to a material irregularity. Moving then finally and briefly to the proviso. We address the proviso at paragraph 52 of our case, 2324. And as we say there, provided the board is satisfied that Mr Major's handwriting evidence was admissible and the jury were properly directed on it, any other material irregularities in this case resulted in no injustice. And we say that because having found Mr Major's evidence reliable, the jury must have rejected the suggestion that the appellant didn't write the suicide note and dismissed his defence that he didn't shoot the deceased. And this would be an appropriate case in those circumstances for the board to apply the proviso on that basis. My lords, my lady, those are my submissions, unless I can be of any further assistance.
No further questions. Mr Poole, thank you very much for your submissions. The board will adjourn to consider its position before it returns. Mr Milo, unless there are matters which you feel you wish to put to us in reply, the board does not consider that it needs to hear from you. Is there something that you were wanting to clarify?
My Lord, I'm grateful for that indication. May I just make a number of factual corrections? Firstly, in relation to the respondent's submission that fingerprints could not be taken from the gun, the respondent relied upon the evidence of Mr Phipps and gave the reference at page 66419. However, he was not the scenes of crime expert. That was Mr Hibbert. And at page 278, line 5, Mr Hibbert said that you can take fingerprints from the gun. And so it could have been done, and there was no explanation why not. Obviously, in relation to that, the presence of the deceased's fingerprints on the gun would have been significant. The other matter which we're conscious we didn't respond to from yesterday, it was a query from Lord Leggett, and that related to whether Mr Edwards was right-handed or left-handed. In the evidence, there's no evidence as to whether he's right or left-handed. However, we did have contact with Mr Edwards just before 11:30 yesterday morning, and he confirmed by email, so this is in advance of many of the comments and arguments, he confirmed by email that he was right-handed, but it's not within the evidence.
Well, within the evidence, I did find that when he picked up the gun, and before dropping it back again, he said he used his right hand, which is some indication that that's the hand he would naturally use.
And there was something, I think, in the summing up suggesting he was right-handed.
He was right-handed, yes.
I think
that might have been her, actually, in the summing up.
The summing up, yes, we have 1325, 1676, 1736. Is the deceased was right-handed.
It's all just the deceased. There was no reference to her, to him.
Not with, but Lord Legate, as always, perhaps is ahead of me in relation to some reference to right-handedness in the evidence there. Yes. The other matter which really arose from Lady Rose yesterday, and that was about the blood smear on the door. And my lady, the question was whether that was in Miss Leake's opinion. And I answered, I think, incorrectly by saying it was within submissions. It is in Miss Leake's report, and it's at page 2080 and 2083. And our submission is and remains an important matter for the board to consider, because she, in her report, explains that smear as being blood and also how it occurred from the deceased's head brushing against the door as the door was opened and the deceased fell. This contrasts with the limitations on the defence at the trial, in that Detective Corporal Mitchell, at page 209, 1822, and this also is in the note we handed up this morning, when he was referred to that mark on the photograph, he said it could be anything. So when it was put to him, it's a smear of blood here for the defence to try and make that point of the position of the body and develop that proposition of the impossibility of the deceased exiting and having that mark there and so on. There was resistance from the officer. It could be anything. So it was not, as the Crown has, as the respondent has put it before the board today, that these propositions were available to the defence to put to the jury based on evidence, because the police, after the passage of time, often resisted. To balance that, Superintendent Phipps at 668 number 20 did agree that that mark looked like blood on the door. But he also said he didn't consider the scene. So there was limitation. So it's really addressing that which Ms Leake considers. The other matter, which again a correction or clarification from my submission yesterday, related to the arterial spurt. And in submissions by the respondent as to the pathology, as to the death of the deceased, and that came from page 586, that the deceased would have been unconscious straight away and dead in minutes. It's 586, 1-9. The pathologist then, Miss Leake then explains at page 2081 that the heart continued to beat a handful of times. And so she examines the blood spatter, identifies an arterial spurt, and therefore concludes that the blood continued to pump from the heart. And that also is significant that could not be seen by a jury looking at these photographs as to lack of blood contact on a person going past the deceased when an arterial spurt was coming out of her head in the way that Miss Leake was able to analyse. So we strongly reject that the jury were able to look at these photographs and reach conclusions on spatter, which was back behind the deceased, an arterial spurt, which again was behind the deceased and also coming to the right-hand corner of the wall. Sorry, the right-hand corner of the door.
Is relevant to it supports the defence because despite that arterial spurt, there was no blood on Mr Edwards.
Yes, it goes, in our submission, it goes further than spatter, which there was some evidence from police about a gaseous type, a fine spatter. And the jury were not directed at all to consider arterial spurt, which is obviously much more substantial. The heart is pressure pushing out blood, which causes much more mess, putting it bluntly. And the jury were never directed to that, that her heart continued to beat. So that was the general point on all those submissions on the photographs. Also, it's not clear exactly which photographs the jury had, whether they had all of these close-up pictures of the deceased.
Did they have the one with the man sitting in the position? Somebody else sat in the position.
This is Miss Leake when she's Leake's demonstration. So this is the reconstruction by the expert. There was no.
So they wouldn't have that.
No, they wouldn't have that. So she did her own reconstruction with a volunteer to work out the blood spattering in the photograph, my lady. There was no. That was the other aspect, of course, that there was no attempt to reconstruct. Is it the page, my lady, page 2080? Is that the page you're thinking of?
Yes.
Demonstration example. And that's where she's considering, because she was specifically asked about the swipe on the door from the photograph. And so she specifically addressed how that could have occurred by having somebody sitting in that position where she'd reconstructed the person to have been.
Yes, I remember now.
And as another general point to clarify, particularly from some of the submissions that have been made today, there was not at any point a suggestion to the jury that suicide was more likely. The only evidence actually eventually came from the pathologist that he could not say whether it was suicide or murder. And so the submissions that have been made that the defence was able to address the jury, that all these factors pointed more to suicide, that again is not supported by the evidence in the case. The defence asked a series of quite often open questions about lack of examination of the crime scene, of shortcomings, that the crime scene was cleaned up. And all the questions of Mitchell are in relation to what should have happened, because by the time he was there, it had all been cleared away. And so he's being questioned that this is what you should have seen, or the absence within a crime scene being significant, but it had all obviously been cleaned. My Lord, the one other point again of clarification, which might be of significance from yesterday and from submissions, also comes from the expert at page 2112, which, if I may just take you to it very quickly. And this, it's in a footnote at number 22.
What are we looking at here?
So this is the firearms. So this is Mr Mastaglio's report.
Could you give me the page number again?
2112.
Okay.
And he, in the footnote at number 22, sets out there the research that shows that the right temple is one of the most common elective sites in suicide. And, my lords, my lady, in the trial, Mr Phipps gave evidence as to a natural site of suicide as being under the chin and in the mouth, and that can be found at 2000. Forgive me, that can be found at page 283. So the relevant pages are, yes, it's at page 283. And he says that murder is more reflective of the shot in the head in his evidence. Now, that again wasn't challenged, but there is evidence there that that is not correct. He describes it as a more natural way of somebody committing suicide as those two methods, but it's not borne out by the expert evidence. My lords, my lady, the only other point, if I may, having taken further instructions overnight, is to focus again very shortly on the constitutional appeal and the unfairness. And the reason I crave your indulgence to return to it very briefly is because it is submitted that it is important within Jamaica that there is not, it is submitted simply a declaration of a breach of Section 16. And when we took you to the case of Cameron yesterday, and we referred to one particular passage where the Supreme Court in Jamaica, in fact, was expressing some frustration at the board's decision in Tapa. And its frustration was expressed in terms of, because this was how the prosecution always behaved there, and they didn't get their witnesses together, that passage that I read yesterday, and that they basically handed off responsibility. And there was frustration from the court in Jamaica that that the prosecution was allowed to do this in effect, and the years go by. And our submission is that in a case like this, where there has been 10 years that have passed, and bearing in mind the points made by the respondent yesterday, that even if there had been some delay at the door of the defence, that delay was not dug underneath. Often, as the board will have seen, the defence is surprised by what evidence it is going to meet. And it seemed that the trial started and they realised there was a need for a handwriting expert, and then it was adjourned. However, if that trial had taken place within a reasonable time, the exhibits still would have been available to the defence. And the submission is that unfairness infects the whole case. That the delay, whilst we focused on the lack of Sergeant Brown and the lack of the jury hearing from her and referring to her evidence, which turned out to be important in relation to the suicide note, our submission is that what occurred in this case and can be seen to occur is that the witnesses were unable to perhaps remember what was other than what was in their notes. However, they were at liberty to add evidence which in each case went against the defendant. And this is what they did. And this is particularly in relation to Mr Phipps, that he added 2 points, that there was a pointing out of the note, and he also added that that Mr Edwards had pretended to cry, effectively made crying noises, and there were no tears, which was the first time he'd come up with that. And so although my Lord Legate has made the point in exchanges with the respondent that effectively after 10 years it might be reasonable for the judge, therefore, to consider, well, there can't be any memory beyond what is written down. But what happens in these trials, and it's demonstrated here in our submission, is that there's no break on the witnesses adding in bits. And then it goes to the jury and it causes prejudice. And this has happened repeatedly. And the submission in relation to the pathologist, which we did address yesterday, but we'd like to refer back to it. If that section is considered where the pathologist is questioned, there's a whole section in that evidence where there's objection, there's discussion as to what the pathologist is going to say next, what's in the notes, what's not in the notes, all of it done in front of the jury. And because there's no procedural rigour, certainly in this case, on what's admissible, what's not admissible, the 10-year delay is not able to be managed by procedure, certainly in this court in Jamaica. It was not able to be managed by legal directions. And what we saw...
Well, the judge is not in control of what comes out of witnesses' mouths either once they're in the witness box. And she had to deal with the situation that was presented to her. So I think...
Yes.
It would be a strong thing to say, if that occurs, there's nothing that the judge can do by direction to ensure a safe conviction.
Yes, certainly the judge should, by direction, hear legal arguments in relation to, after such a delay, hear legal arguments in relation to the delay and any impact upon the evidence by the missing witnesses, what's agreed, what's in dispute, and so on. It didn't happen in this case. And so the result was that in our submission, the judge did not appear to know how to deal with the delay, other than to allow all the evidence to go forth and wait for objections. And in our submission, this is another reason as to why the delay creates unfairness, because the prejudice then comes in, and as has been pointed out, when witnesses are missing. So that was really the addition on the constitutional point. And similarly, yes, I think that's the conclusion on the constitutional point. If I may just finally on the handwriting expert on Mr Major, the submission with Mr Major is that the respondent hasn't addressed at all that the methodology was flawed. This isn't best practice. This is about Mr Hayward saying you cannot come to a safe conclusion to give an opinion on that handwriting with this specimen. It's not about best practice and being able to reach a conclusion. It's quite the opposite, and hence the submission that it's flawed. And the summing up, the judge does not refer to the methodology being flawed. It's at page 1780. She just simply says it's up to the jury. bearing in mind the board's indication, and I've trespassed a little on some of the time, but I hope with the focus on the constitutional issue, I don't propose to address any further, and bearing in mind the indication, unless there's any points I might be able to assist with.
Thank you very much, Ms Brimley. Well, the board is very grateful to council for their clear submissions, and also to those who have assisted in the preparation of those submissions and in the preparation of the papers for this appeal. The board will take time to consider what advice they will humbly tender to Her Majesty. The board will now adjourn.